17th Amendment to the United States Constitution.
The 17th Amendment to the United States Constitution established direct election of United States Senators by popular vote. The amendment supersedes Article I, SS 3, Clauses 1 and 2 of the Constitution, under which senators were elected by state legislatures. It also alters the procedure for filling vacancies in the Senate, allowing for state legislatures to permit their governors to make temporary appointments until a special election can be held. Under the original provisions of the Constitution, senators were elected by state legislatures. This was intended to prevent the federal government from indirectly absconding with the powers and funds of the states. However, over time various issues with these provisions, such as the risk of corruption and the potential for electoral deadlocks or a lack of representation should a seat become vacant, led to a campaign for reform. Reformers introduced constitutional amendments in 1828, 1829, and 1855, with the issues finally reaching a head during the 1890s and 1900s. Progressives, such as William Jennings Bryan, called for reform to the way senators were chosen. L.A. Root and George Frisbee Hall were prominent figures in the campaign to maintain the state legislative's election of senators. By 1910, 31 state legislatures had passed motions calling for reform. By 1912, 239 political parties at both the state and national level had pledged some form of direct election, and 33 states had introduced the use of direct primaries. With a campaign for a state-led constitutional amendment gaining strength, and a fear that this could result in a runaway convention, the proposal to mandate direct elections for the Senate was finally introduced in the Congress. It was passed by the Congress and, on May 13, 1912, was submitted to the states for ratification. By April 8, 1913, 3/4 of the states had ratified the proposed amendment, making it the 17th Amendment. Secretary of State William Jennings Bryan formally declared the amendment's adoption on May 31, 1913. Critics of the 17th Amendment claim that by altering the way senators are elected, the states lost any representation they had in the federal government and that, in addition to violating the unamendable state suffrage clause of Article V, this led to the gradual slide into ignominy of state legislatures, as well as an overextension of federal power and the rise of special interest groups to fill the power vacuum previously occupied by state legislatures. In addition, concerns have been raised about the power of governors to appoint temporary replacements to fill vacant Senate seats, both in terms of how this provision should be interpreted and whether it should be permitted at all. Accordingly, noted public figures have expressed a desire to reform or even repeal the 17th Amendment.
Background. Original composition.
Originally, under Article I, SS 3, Clauses 1 and 2 of the Constitution, each state legislature elected its state's senators for a 6-year term. Each state, regardless of size, is entitled to 2 senators as part of the Connecticut Compromise between the small and large states. This contrasted with the House of Representatives, a body elected by popular vote, and was described as an uncontroversial decision to make. James Wilson was the sole advocate of popularly electing the Senate and his proposal was defeated 10-1. There were many advantages to the original method of electing senators. Prior to the Constitution, a federal body was one where states effectively formed nothing more than permanent treaties, with citizens retaining their loyalty to their original state. However, under the Constitution the states were subordinated to a central government. The election of senators by the states reassured anti-federalists that there would be some protection against the swallowing up of states and their powers by an ever-expanding federal government, providing a check on the power of the federal government. Additionally, the longer terms and avoidance of popular election turned the Senate into a body to temper the populism of the House. While the representatives existed in a 2-year direct elections cycle, the senators could afford to take a more detached view of issues coming before Congress. State legislatures also retain the theoretical right to instruct their senators to vote for or against proposals, giving them both direct and indirect representation in the federal government. The Senate also provided formal bicameralism, with the members of the Senate and House responsible to completely distinct constituencies. This helped defeat the problem of the federal government being subject to special interests. Members of the Constitutional Convention also saw it as an equivalent to the House of Lords, containing the better men of society. It was hoped that they would provide more coolness and stability than the House of Representatives due to the senator's status.
Issues.
According to Judge J. B. of the United States Court of Appeals for the Ninth Circuit, those in favor of popular elections for senators felt that there were primarily two problems caused by the original provisions: legislative corruption and electoral deadlocks. In terms of corruption, the general feeling was that senatorial elections were bought and sold, changing hands for favors and sums of money rather than because of the competence of the candidate. Between 1857 and 1900, the Senate investigated 3 elections over corruption. In 1900, for example, William A. Clark had his election voided after the Senate concluded that he had bought votes in the Montana legislature. However, B. and Todd Zywicki believe this concern was largely unfounded. There was a dearth of hard information on the subject, and in over a century of elections, only 10 were contested with allegations of impropriety. Electoral deadlocks were another issue. Because state legislatures were charged with deciding who to appoint as senators, the system relied on them being able to agree. Some states could not, and thus delayed sending representatives to Congress. In a few cases, the system broke down to the point where states completely lacked representation. Between 1891 and 1905, 46 elections were deadlocked, in 20 different states. In one extreme example, a Senate seat for Delaware went unfilled from 1899 until 1903. The business of holding elections also caused great disruption in the state legislatures, with a full third of the Oregon House of Representatives choosing not to swear the oath of office in 1897 due to a dispute over an open Senate seat. The result was that the legislature was unable to pass legislation that year. Zywicki again argues that this was not a serious issue. Deadlocks were a problem, but they were the exception rather than the norm. Many legislatures did not deadlock over elections at all. Most of those that did in the 19th century were the newly admitted Western states, which suffered from inexperienced legislatures and weak party discipline. As Western legislatures gained experience, deadlocks became less frequent. While Utah suffered from deadlocks in 1897 and 1899, they became a good teaching experience, and Utah never again failed to elect senators. Another concern was that when deadlocks occurred, state legislatures found themselves unable to conduct their normal business. James Christian Ure, writing in the South Texas Law Review, notes that this did not in fact occur. In a deadlock situation, state legislatures would deal with the matter by holding one vote at the beginning of the day. Then the legislators would continue with their normal affairs. There was also a feeling that state legislative elections themselves had become dominated by the business of picking senators, with legislators elected based on their intentions in senatorial elections rather than their opinions on local issues.
Calls for reform.
Calls for a constitutional amendment regarding Senate elections started in the early 19th century, with Henry A. Storrs in 1826 proposing an amendment to provide for popular election. Similar amendments were introduced in 1829 and 1855, with the most prominent proponent being Andrew Johnson, who raised the issue in 1868 and considered the idea's merit so palpable that no additional explanation was necessary. The 1860s also saw the first major congressional disputes over the issue, with the House and Senate voting to veto the appointment of John P. Stockton to the Senate due to his approval by a plurality rather than a majority. In reaction, the Congress passed a bill in July 1866 that required state legislatures to elect senators by an absolute majority. By the 1890s, support for the introduction of direct election for the Senate had substantially increased, and reformers worked on 2 fronts. On the first front, the Populist Party incorporated the direct election of senators into its Omaha platform, adopted in 1892. In 1908, Oregon passed the first law that based the selection of U.S. senators on a popular vote. Oregon was soon followed by Nebraska. Proponents for popular election noted that 10 states already had non-binding primaries for Senate candidates, in which the candidates would be voted on by the public, effectively serving as advisory referenda instructing state legislatures how to vote. Reformers campaigned for more states to introduce a similar method. William Randolph Hearst opened a nationwide popular readership for direct election of U.S. senators in a 1906 series of articles using flamboyant language attacking the treason of the Senate in his Cosmopolitan magazine. David Graham Phillips, one of those yellow journalists Teddy Roosevelt called muckrakers, described Nelson Aldrich of Rhode Island as the principal traitor among the scurvy lot in control of the Senate by theft, perjury and bribes corrupting the state legislatures to gain election to the Senate. A few state legislatures began to petition the Congress for direct election of senators. By 1893, the House had the two-thirds vote for just such an amendment. However, when the joint resolution reached the Senate, it failed from neglect, as it did again in 1900, 1904 and 1908. Each time the House approved the appropriate resolution, and each time it died in the Senate. On the second national legislative front, reformers worked towards a constitutional amendment, which was strongly supported in the House of Representatives but initially opposed by the Senate. Bybee notes that the state legislatures, who would lose power if the reforms went through, were supportive of the campaign. By 1910, 31 state legislatures had passed resolutions calling for a constitutional amendment allowing direct election, and in the same year 10 Republican senators who were opposed to reform were forced out of their seats, acting as a wake-up call to the Senate. Reformers included William Jennings Bryan, while opponents counted respected figures such as Ellie Root and George Frisbee Hoare amongst their number. Root cared so strongly about the issue that after the passage of the 17th Amendment, he refused to stand for re-election to the Senate. Bryan and the reformers argued for popular election through highlighting perceived flaws with the existing system, specifically corruption and electoral deadlocks, and through arousing populist sentiment. Most important was the populist argument that there was a need to awaken, in the senators, a more acute sense of responsibility to the people, which it was felt they lacked. Election through state legislatures was seen as an anachronism that was out of step with the wishes of the American people, and one that had led to the Senate becoming a sort of aristocratic body, too far removed from the people, beyond their reach, and with no special interest in their welfare. Hoare replied that the people were both a less permanent and a less trusted body than state legislatures, and that moving the responsibility for the election of senators to them would see it passing into the hands of a body that, but a day before changing. Other counter-arguments were that renowned senators could not have been elected directly, and that since a large number of senators had experience in the House, which was already directly elected, a constitutional amendment would be pointless. It was also seen as a threat to the rights and independence of the states, who were sovereign, entitled to have a separate branch of Congress, to which they could send their ambassadors. This was countered by the argument that a change in the mode in which senators were elected would not change their responsibilities. The Senate freshman class of 1910 brought new hope to the reformers. 14 of the 30 newly elected senators had been elected through party primaries, which amounted to popular choice in their states. More than half of the states had some form of primary selection for the Senate. The Senate finally joined the House to send forward the 19th Amendment for direct election of U.S. senators, nearly 90 years after it first was presented to the Senate in 1826. By 1912, 239 political parties at both the state and national level had pledged some form of direct election, and 33 states had introduced the use of direct primaries. 27 states had called for a constitutional convention on the subject, with 31 states needed to reach the threshold. Arizona and New Mexico each achieved statehood that year, bringing the total number of states to 48, and were expected to support the motion, while Alabama and Wyoming, already states, had passed resolutions in favor of a convention without formally calling for one.
Proposal and ratification. Proposed by the Congress.
In 1911, the House of Representatives passed House Joint Resolution 39 proposing a constitutional amendment for direct election of senators. However, it included a race rider meant to bar federal intervention in cases of racial discrimination among voters. When the resolution came before the Senate, a substitute resolution, one without the rider, as proposed by Joseph L. Bristow of Kansas. It was adopted by a vote of 64 to 24, with 4 not voting. Nearly a year later, the House accepted the change. The conference report that would become the 17th Amendment was approved by the Senate 42 to 36 on April 12, 1912, and by the House 238 to 39, with 110 not voting on May 13, 1912.
Ratification by the states.
Having been adopted by Congress, the amendment was sent to the states for ratification and was ratified by Massachusetts, May 22, 1912, Arizona, June 3, 1912, Minnesota, June 10, 1912, New York, January 15, 1913, Kansas, January 17, 1913, Oregon, January 23, 1913, North Carolina, January 25, 1913, California, January 28, 1913, Michigan, January 28, 1913, Iowa, January 30, 1913, Montana, January 30, 1913, Idaho, January 31, 1913, West Virginia, February 4, 1913, Colorado, February 5, 1913, Nevada, February 6, 1913, Texas, February 7, 1913, Washington, February 7, 1913, Wyoming, February 8, 1913, Arkansas, February 11, 1913, Maine, February 11, 1913, Illinois, February 13, 1913, North Dakota, February 14, 1913, Wisconsin, February 18, 1913, Indiana, February 19, 1913, New Hampshire, February 19, 1913, Vermont, February 19, 1913, South Dakota, February 19, 1913, Oklahoma, February 24, 1913, Ohio, February 25, 1913, Missouri, March 7, 1913, New Mexico, March 13, 1913, Nebraska, March 14, 1913, New Jersey, March 17, 1913, Tennessee, April 1, 1913, Pennsylvania, April 2, 1913, Connecticut, April 8, 1913. The amendment was rejected by Utah, February 26, 1913, Delaware, March 18, 1913. With 36 states having ratified the 17th Amendment, it was certified by Secretary of State William Jennings Bryan on May 31, 1913, as part of the Constitution. The amendment has subsequently been ratified by Louisiana, June 11, 1914, Alabama, April 11, 2002, Delaware, July 1, 2010, Maryland, April 1, 2012. No action on the amendment has been completed by Florida, Georgia, Kentucky, Mississippi, Rhode Island, South Carolina, Virginia.
Effect.
The 17th Amendment altered the process for electing United States senators and changed the way vacancies would be filled. Under the original constitutional provision, state legislatures filled vacancies when a senator left office before the end of the term. The 17th Amendment provides that state legislatures can grant governors the right to make temporary appointments, which last until a special election is provided to fill the seat. The power to call such an election can also be granted to the governor. It also had an immediate and dramatic impact on the political composition of the U.S. Senate. Before the Supreme Court required one man one vote, rural counties and cities were given equal weight in the state legislatures, enabling one rural vote to equal 200 city votes. The mal-apportioned state legislatures would have given the Republicans control of the Senate in the 1916 Senate elections. With direct election, each vote represented equally, the Democrats retained control of the Senate. The reputation of corrupt and arbitrary state legislatures continued to decline as the Senate joined the House of Representatives implementing popular reforms. Judge Bybee has argued that the amendment led to complete ignominy for state legislatures without the props of a state-based check on Congress. Progressive measures were enacted to enable the federal government to supersede the discredited states repeatedly over decades. New Deal legislation is another example of expanding federal regulation overruling the state legislatures promoting their local state interests in coal, oil, corn and cotton. Ure agrees, saying that not only is each senator now free to ignore his state's interests, senators have incentive to use their advice and consent powers to install Supreme Court justices who are inclined to increase federal power at the expense of state sovereignty. Over the first half of the 20th century, with a popularly elected Senate confirming nominations both Republican and Democratic, the Supreme Court began to apply the Bill of Rights to state law, overturning it wherever it harmed individual state citizens by applying the 14th Amendment.
First direct elections to the Senate.
Oklahoma, admitted to statehood in 1907, chose a senator by legislative election 3 times, twice in 1907, when admitted, and once in 1908. In 1912, Oklahoma re-elected Robert Owen by advisory popular vote. New Mexico, admitted to statehood in 1912, chose only its first 2 senators legislatively. Arizona, admitted to statehood in 1912, chose its first 2 senators by advisory popular vote. Alaska, and Hawaii, admitted to statehood in 1959, have never chosen a U.S. senator legislatively. The first direct elections to the Senate following the 17th Amendment being adopted were in Maryland on November 4, 1913, a Class I special election due to a vacancy, for a term ending in 1917, in Alabama on May 11, 1914, a Class III special election due to a vacancy, for a term ending in 1915, nationwide in 1914, all 32 Class III senators, term 1915 to 1921, nationwide in 1916, all 32 Class I senators, term 1917 to 1923, nationwide in 1918, all 32 Class II senators, term 1919 to 1925.
Interpretation and advocacy for reform.
In Trinity v. Pennsylvania, 1991, the United States Court of Appeals for the Third Circuit was faced with a situation where, following the death of Senator H. John Hines III of Pennsylvania, Governor Robert P. Casey had provided for a replacement and for a special election that did not include a primary. A voter and prospective candidate, John S. Trinity, Jr., argued that the lack of a primary violated the 17th Amendment and his right to vote under the 14th Amendment. These arguments were rejected by the Third Circuit, which ruled that the 17th Amendment does not require primaries. Another subject of analysis is whether statutes restricting the authority of governors to appoint temporary replacements are constitutional. Vikram Amma, writing in the Hastings Constitutional Law Quarterly, claims that Wyoming's requirement that its governor fill a senatorial vacancy by nominating a person of the same party as the person who vacated that Senate seat violates the 17th Amendment. This is based on the text of the 17th Amendment, which states that the legislature of any state may empower the executive thereof to make temporary appointments. The amendment only empowers the legislature to delegate the authority to the governor and, once that authority has been delegated, does not permit the legislature to intervene. The authority is to decide whether or not the governor shall have the power to appoint temporary senators, not in what fashion he should do so. Sanford Levinson, in his rebuttal to Amma, argues that rather than engaging in a textual interpretation, those examining the meaning of constitutional provisions should interpret them in the fashion that provides the most benefit, and that legislatures being able to restrict gubernatorial appointment authority provides a substantial benefit to the states. Due to the controversy over the impact of the 17th Amendment, there has been advocacy for both reform and repeal of the 17th Amendment. With the commencement of the Obama administration in 2009, 4 sitting Democratic senators left the Senate for executive branch positions: Barack Obama, President; Joe Biden, Vice President; Hillary Rodham Clinton, Secretary of State; and Ken Salazar, Secretary of the Interior. Controversies developed about the successor appointments made by Illinois Governor Rod Blagojevich and New York Governor David Paterson. This created interest in abolishing Senate appointment by the governor. Accordingly, Senator Russ Feingold of Wisconsin and Representative David Dreyer of California proposed an amendment to remove this power. Senators John McCain and Dick Durbin became co-sponsors, as did Representative John Conyers. The Tea Party movement has been at the forefront of the campaign to repeal the 17th Amendment entirely, arguing that it would protect states' rights and reduce the power of the federal government.